Well, good morning, everybody. Welcome to the latest installment of MichBio U, or the MichBio webinar series. Today's topic is Introduction to Intellectual Property Agreements and Licensing. And with us today is going to be Nicholas Baller and Jason Tajani at the law firm of Warner, Norcross, and Judd. Just to remind everybody on the call today that these webinars are recorded and archived on the MichBio member website, so you can always go back to them at your leisure. And our next webinar is still to be scheduled, but keep an eye out through our newsletters and emails and events calendar, and we'll be posting them as soon as we have them. So without further ado, I'm going to turn it over to Jason Tajani, who's going to walk you through the presentation this morning. Jason, welcome. Thank you for the presentation, and it is all yours.
Thank you, Stephen. Good morning, everyone. As Stephen stated, Stephen, does this look the same? Make sure we have the same presentation here.
Yep. Just go ahead and put it into slideshow mode.
There we go.
And I should also add to those attending that if you have any questions, please just use the chat format to submit any of your questions, and we'll have those answered at the end of the presentation. So, Jason, all yours.
Thanks, Stephen. Okay, so we're going to talk today about an introduction to intellectual property agreements and licensing. As Stephen indicated, I am an attorney with the law firm of Warner, Norcross, and Judd. And with me is Nicholas Baller. He's a patent agent. He has a PhD from Caltech with a variety of experience in the biotech field. Good morning. So our agenda today will include 4 parts. First, we're going to discuss the purpose of agreements, why a startup, an entrepreneur, inventors, why you may see these agreements and what you need them for. Second, we're going to talk about the types of agreements that you may come across. The third, we're going to break down these agreements and describe the parts of the agreements and their terms. And then we'll go into some application and look at 2 scenarios that utilize what we've learned throughout the first 3 parts. So in general, the scope of this presentation is to build a high-level awareness of various IP agreements and the terms that are contained therein. You know, I'm a patent attorney, so this is going to be patent-centric, but I will add in commentary regarding trademarks and copyrights where necessary. I'm also a U.S. attorney, so I can only speak to U.S. law. And, you know, on the basis of this presentation, I don't recommend firing your IP attorney. You know, I really want to help you be able to identify certain agreements, the terms in the agreements that you might likely see, and then be able to ask the correct questions and utilize your attorney more efficiently to lower the overall cost. So first, the purpose of IP agreements. IP agreements, they generally define 5 principles. I consider these pillars of agreements: ownership, control, responsibility, compensation, and then termination and dispute resolution. While all agreements may not include all 5 of these pillars, a majority of them will include at least 3 or 4, and some more. During negotiation, these elements can be manipulated like levers to help you arrive at a commercially sound agreement. In some cases, the agreement may not be in your favor, but you can utilize these pillars and these levers to balance out so that you can arrive at a commercially favorable position. Now we'll go further into each of these pillars. First, ownership. The benefit for obtaining ownership of IP includes the ability to enjoin others from exploiting IP. What this means is you are able to assert a suit of infringement against another. You are able to stop them from practicing your IP. While ownership of IP does not give you a freedom to operate, it does give you an ability to stop others from operating your space. The second benefit is your ability to license IP. Maybe you are an IP holding company, or you're an inventor developing IP that needs to commercialize with a larger entity. This will allow you to control who you work with utilizing your IP and then come up with some type of arrangement that's beneficial to you. Third, if you do need to sue for infringement, ownership gives you standing. Standing is required to be able to assert lost profits. If you weren't injured in the suit by not having ownership, then you would not have lost profits. So it's a mechanism to allow you to obtain a favorable reward if it comes to that. Now, there are common responsibilities with IP ownership. These include maintenance fees and annuity payments for patents. While one or two patents may not be detrimental to the pocketbook, many large IP portfolios can cost hundreds of thousands of dollars to maintain on a yearly basis. So this is something that patent owners need to consider when partnering with somebody else, another entity. Also, although it's a benefit that you can join suit for IP infringement, it's also a responsibility that you have to if you are if you are an owner. Now, potential consequences for failing to consider ownership. So one of the consequences may be joint ownership. In some cases, that may be your end goal is joint ownership of IP with another entity. However, you can be in the strongest position when you maintain full ownership. For example, a co-owner may independently license the IP to a third party. That third party may be your competitor and not theirs. Second, the co-owner could refuse to join suit if you're potentially threatening suit against a party that they are working with, maybe in a customer relationship. Third, that co-owner can be commercially competitive against you. They can undercut you for pricing. They can operate just as you can with that IP. And so you may be in competition with that co-owner. On the other hand, you may not have any ownership at all if you don't consider ownership. Bear with me. Oh, there we go. Now, in some cases, IP ownership may not be available. You may not be in the strongest position to maintain your IP ownership. So we can use these pillars, the other four pillars, as levers during negotiation to obtain a more favorable position. Once again, these levers include control, responsibility, compensation, and dispute resolution. Now, for control, there are various forms of control. You can pursue or limit licensing of IP, the ability to be able to choose who commercializes your IP, or to limit who can commercialize your IP by obtaining an exclusive license can be very beneficial to you, even if you do not have ownership of the IP. You may be able to limit exploitation of the IP to a certain field or geographic territory. Maybe this field or geographic territory are the only areas you're commercializing in, so limiting it to these areas and territories may be suitable. You may also be able to control IP procurement. You may be able to decide where you want to file. Maybe the US isn't enough for your technology. Maybe you want it to be in Europe, China, Japan, Germany, other countries, specific countries, Germany, rather than just Europe broadly. Also, you can control the claim scope. You may want to make sure that your commercial product is captured within the claims. And finally, you can control enforcement. You may want to be able to choose who to enforce against. It may be a situation where your infringer may be your customer in another scenario. And so there might be other ways to work with that potential infringer rather than suing them. And by having that control, you can look into those avenues. The next pillar is responsibility. What does it take to operate within these agreements? There are IP procurement costs. These costs are expensive. Some portfolios can cost $20,000 to obtain on the low end and $100,000 on the high end just to obtain coverage in the areas that you'd like. That doesn't include the maintenance fees and annuity payments for those patents. In addition, you may be able to work with responsibility on confidentiality. In most of these cases, agreements always include clauses regarding confidentiality, but you may be able to change the terms of the confidentiality, limit the amount of burden that's on you. At the same time, you can also work on different type of representations and warranties. Representations and warranties are typically what you say you own, what you say you're going to produce, what's the quality of that product, what are the ramifications if you don't provide a product that's up to spec. You may be able to negotiate to a more favorable position if you don't have ownership of the IP. Now, moving specifically to confidentiality, in most entities, information of a company can be described in a pyramid. Confidential information typically expands the breadth of the pyramid, the majority of it. This information can generally be disclosed under agreement, but it should be kept confidential otherwise. On the other end, you have the trade secret, which should only be disclosed when absolutely necessary. And on the bottom, just common public knowledge. You can utilize confidentiality as one of your levers to determine how much information you're giving to your collaborator. Now, still continuing on responsibilities, we're moving on to representations and warranties. Some of these representations may be made that you're a sole and exclusive owner of the IP if you're working with another entity. You may want to make sure that your employees and developers have assigned all their rights to you so that you are able to say, yes, I am a sole and exclusive owner. You also may have to make sure there's no encumbrances to your ability to practice or license the technology, that you haven't already got into an exclusive arrangement with somebody else that would prevent you from working with another party. You may also have to state that your IP does not infringe third-party rights, or that you have not had any maintenance fee or annuity lapses, or that your claims are actually valid. Now, in practice, we like to use a little ambiguity with some of these terms. We usually try to write in "to the best of my knowledge," because especially when it comes to validity, it's very hard to know every piece of prior art out there and every argument that can be made. And typically, having that ambiguity does help to come to an agreement. And moving on to compensation as one of the pillars, you can work on the sale of the IP rights. If you're going to not be an owner, what's the price that you will pay, you will take for that IP? What royalty arrangement can you come up with based on product that's produced utilizing your IP? And there's other compensatory mechanisms as well. These can include agreements to purchase material in exchange for IP ownership, or potentially exclusivity related to practicing the IP. However, you do need to make sure that you look out for antitrust issues. Antitrust laws exist to promote competition among sellers, limit monopolies, and give consumers more options. If your other compensatory mechanism appears to limit competitiveness, you may have an antitrust issue. For example, if you're attempting to tie the sale of an unrelated product in exchange for IP ownership, that may be considered an antitrust issue. Now, the final pillar, termination dispute resolution, this pillar does not have a lot of weight. You typically want to focus on control and responsibility, and of course compensation. But here you can define the allocation of IP upon termination. So if you are holding the IP as a joint development where you're jointly owned, what happens if the parties terminate the agreement? Have you written in there who gets what? You may also have in this portion remedies for failure to deliver what's promised, whether it's a product or some research. You can define the cost shifting of that failure. You can define the scope and burden of investigation to prove that there has been a failure. Also, you can focus on governing law, jurisdiction, and venue for favorable jurisdiction and law. And you can work on the type of dispute resolution. Mediation is common in these circumstances. Now, moving on, we can go to the types of IP agreements that you might likely see. While this list is not exhaustive, several include non-disclosure agreements, assignments, employment agreements, license agreements, joint development agreements, and sponsored research agreements. Go into each of these in detail. A non-disclosure agreement is an agreement between two or more parties that defines confidential material. The agreement may be unilateral or bilateral. What that means is the agreement may be on only a single party between the two parties or both parties. An important point that I introduced earlier is that defining confidential material can be important. You want to make sure you have a balance between being inclusive and maintaining a position that's not too burdensome for holding that confidential material. For example, there's various mechanisms that may be necessary to share confidential information between parties. Some transactions require data rooms, special cloud-based servers that both parties have controlled access to ensure that the confidential information remains safe. You also may need to restrict disclosure of your confidential information even within your organization to a specific subset of people. Now, for anyone that's really worked on patents before, you've probably seen assignments. An assignment is an evidence of a transfer of IP rights from one party to another. An assignment can also transfer ownership interests of patents that do not yet exist because they may be based on an invention or a specific subject matter. Now, an assignment may transfer the IP in its entirety to one party. It may transfer an undivided interest in the IP between multiple parties, or separate rights for the IP to a specific geographical region. Now, one thing, assignments, you cannot divide ownership within a patent on a claim-by-claim basis, and you cannot separate them on any exclusivity related to make, use, sell, offer to sell, or import. What that means is you can't take a single patent and assign only the composition claims to one party and the method claims to another party. Now, an employment agreement will contain a variety of clauses completely unrelated to IP, but in most of them, they do include an IP portion. This portion ensures that any IP developed in the course of business of an employee or a contractor is assigned or intended to be assigned to the employer. The scope may relate to any work that relates to the employer's business, and the agreement may also include a provision that requires the employee to cooperate to procure, enforce, and maintain the employer's IP. What this means is that even after termination of an employee, global patent portfolios may require documentation for several years even after the first filing. This allows the employer to work with that original inventor and ensure that they will sign any documents that are necessary to procure the patent in those situations. Next is a license agreement. A license agreement is an agreement between an owner of IP, which is the licensor, and another who is authorized to use the IP, a licensee, in exchange for some form of compensation. The IP license may be exclusive, where it grants IP rights to the licensee, excluding all others, or non-exclusive, where the IP license the rights are granted to the licensee and maybe to a variety of other licensees that could compete with that original licensee. Now, the compensation may be a fee or a royalty, or it may be a cross-license, meaning if both parties have IP that both are interested in, they can form a cross-license as the compensation for this license agreement. The next agreement we'll look at are joint development agreements. These agreements are typically utilized in a variety of situations and can be complex. Joint development agreements include the provisions of the agreements we just discussed. So they include non-disclosure of confidential information, they include assignment of IP rights, and they can include licensing of IP. What these agreements are for is to enable unaffiliated parties to pursue more efficient commercialization of their technology by leveraging their combined technical expertise. One party may develop a compound for another party that is commercializing products that utilize that compound. It's a mutually beneficial arrangement, and these are the agreements that they typically enter into. Similar to a joint development agreement, and maybe familiar to many in the university space, are sponsored research agreements. While they have this similar underlying purpose to bring two parties together to achieve some type of commercialization goal, these are different in their scope. In many cases, joint development agreements can define a specific problem or a technology that one party is going to pursue for the other or together. With research agreements, it's typically a foundational technology that may have many applications. So defining the scope can be difficult if just focusing on the problems or the solutions. So here it's very important to clearly define the goals of the project, to understand and identify the parties' respective roles and contributions, and the manner in which these parties are going to work together, including timelines and deliverables. And the next part relates to breaking down IP agreements. Now, all of these agreements have various parts. I'm going to hit on the most common parts of the agreements and some agreement parts I think are very important for these agreements as well. So with non-disclosure agreements, of course, we're going to see the parties in the agreements, defining who the parties are. We're going to define what the business purpose of the agreement is. This helps with scope, especially in large organizations, ensuring that one NDA doesn't expand beyond an entire organization. Providing a definition of confidential information, once again, to balance the burdensomeness of confidential information with the inclusiveness. It will also include non-disclosure obligations. What ways are you going to prevent non-disclosure? Prevent disclosure. It's going to include use and access restrictions if it's related to certain parties within the organization, and safekeeping requirements. Maybe requirements relating to purging data after a certain number of years. And this agreement is also going to include term. Now, one interesting thing about non-disclosure agreements is, although the agreement for the non-disclosure can end, there should be provisions in there that there's survival of the non-disclosure obligations, especially as it relates to trade secrets, if those are part of the agreement. And there may also be provisions in the agreement relating to the return or destruction of confidential information. Now, for assignments, they're a bit more straightforward. We want to talk about the definition of the IP being transferred. So if we have as broad or ambiguous as the subject matter or the title of the invention of the application, or a name of the invention, to as specific as the patent number. In many assignments, they may include representations and warranties that the assigner has title to actually assign the IP. Now, this typically doesn't occur in assignments from inventors to entities, but it can occur during entity-to-entity transfers. Now, the assignment may be an actual assignment with the IP listed. It may be a future assignment of any IP developed, or it may be an option to assign that gives the assignor the option to receive the IP, the assignee the option to receive the IP. You may also see the presence of third-party claims and indemnification from claims relating to IP in assignments. This typically, once again, is not in assignments from inventor to entity, but you may see this in assignments from entity to entity. And in most of these assignments, you'll also see, once again, assigner assistance to complete transfer if there's any additional documentation or correction necessary after the original assignment has been executed. Now, employment agreements, their assignment provisions are similar to an assignment, except in most cases, the IP has not yet been developed. It may be in the course of their employment, and hopefully the employment agreement is signed before they begin employment. So typically the form of assignment is a future or an option to assign, and it also will include the employee's assistance to complete the transfer or any documents related to the transfer. Now, license agreements can include a variety of terms. In this case, I tried to include as many that you may commonly see in license agreements, but you may not see them all, and they may not all be relevant to your particular situation. I'll go through them briefly. Of course, you want to have a description of the IP being licensed. Typically, it's finite, relating to the patent number, but there have been cases where you can talk about a technology or a trade secret. You can license a trade secret. So in those cases, you're not licensing a patent number, but you're licensing a technology or know-how. You'll also include ownership and use provisions related to the IP. Regarding exclusivity and non-exclusivity as well, obviously exclusivity is preferred in many situations. It gives you the ability to exclude others while still not owning the IP, but in many cases, non-exclusivity is all you're able to bargain for. License may include a field of use, territory, or other restrictions on scope, and this may be related to exclusivity or non-exclusivity. You may have exclusivity to only a certain region or a certain use of the technology. You'll be able to obtain rights and limitations on assigning, sub-licensing, or transferring rights. This is something that we do look at quite a bit. Many companies may use other facilities to produce their product that are not part of that entity. And so having the ability to assign or sub-license certain rights from an IP license is important for them to do business. There also may be grant-back obligations. And in certain cases, it's very favorable. If you've developed IP and you're providing a license to another entity to practice your IP, any improvements they make, you'd like to have a non-exclusive license to those improvements, even though they've made them. And they would technically be part of their IP portfolio, not yours, in many cases. For trademarks, you look at licenses. For trademark licenses, you look at goods and services, quality control, and approvals. You want to make sure that whoever is then assigned your trademark license is utilizing it in the best way, in a way that's defined in the agreement. You also can define license fees and royalties, reps and warranty, license fees and royalties, reps and warranties, and indemnification for IP infringement. And terms and termination are always included in the license agreement, even if it's perpetual. Next type of agreement we'll talk about are the joint development sponsored research agreements. These will include similar provisions. The most important for this discussion can include the allocation of ownership and cross-licensing. So ownership, when two parties want to work together, can be difficult. It's very important to first define what IP everyone is bringing to the table, and then defining how the IP is going to form with this new venture together. So background IP is what you're bringing to the table, and foreground IP is what's been jointly made. Now, with background IP, it's important to minimize the scope of background IP if you can. In many cases, these joint development agreements may include cross-licensing provisions to the background IP, and you may not want this joint developer to have access to all of your patents. At the same time, foreground should also consider scope as well. You don't want your own technology that may be unrelated to this joint venture falling under this agreement and therefore becoming foreground IP, which could be subject to joint ownership. You also find prosecution and maintenance instructions agreements in these agreements. Who's going to control prosecution? What countries will a certain party pay for maintenance fees or annuities? That should be defined. You may also discuss commercialization. Which suppliers are you allowed to license to when you're starting to commercialize? Which parties are going to do what in this commercialization scheme? And they can also describe enforcement and the effects of termination on the collaboration. If the foreground IP is jointly owned, and if this arrangement ends, who's going to own the IP at the end? Are you going to maintain it as a joint ownership, or are you going to separate it in some way? So now that we've talked about the agreements and the part of agreements, I have two hypothetical scenarios that will hopefully solidify everything I've said. So this scenario, here's an overview of the scenario. We have an inventor A. They're developing a microvalve for small fluid transfer. And there's a new thriving startup company in California called Theranos. And they're developing a blood testing device that requires the microvalve for controlling the flow of blood to be analyzed. Of course, this is all hypothetical. Now, in scenario one, we're going to look at it from the inventor's point of view, inventor A. Here, neither the inventor nor Theranos have patents or patent applications on their technology. All technology is currently maintained as confidential within both organizations. Theranos would like inventor A to supply Theranos with the microvalves. Theranos prepares a supply agreement to include IP ownership and licensing provisions. In particular, Theranos would like to own all foreground IP and receive a license to inventor A's background IP relating to the microvalve. Here, Theranos wants to make sure that if they utilize this microvalve, they can freely commercialize the technology. At the same time, as being the bigger player in the potential bigger player in the field, they also want to make sure they have ownership of the IP. The inventor A here sees an opportunity to work with Theranos, so may be willing to give up ownership. However, on its face, there are some problems. The levers are being pulled between ownership and opportunity, where opportunity is with the inventor A, but ownership is falling all on Theranos. Inventor A does not own any patents that clearly define the scope of his background IP. Meaning background IP could be a bit ambiguous at the moment. If this inventor is focusing on microvalves, the inventor does not want other developments in related technologies to fall within this agreement. Theranos will obtain full ownership of all foreground IP relating to the blood testing device. What may happen here is that Theranos may be able to preclude inventor A from practicing any improvements that they make to the technology, to the microvalve during this joint venture with the blood testing device. And Theranos will also obtain a license to inventor A's background IP relating to the microvalves. The license to background IP is quite broad. It may relate to technology, although it's microvalves, that Theranos is not interested in commercializing, and that inventor A is not willing to give to Theranos. So the solution here. So we know we can't obtain ownership of this IP. Well, what can we do to balance the field? Well, we can utilize control and compensation. So with control, we can limit the scope of the background IP. In the agreement, we can require that the background IP is necessary to fulfill the requirements of the agreement. That way, any background IP that could be related to microvalves but is not necessary to fulfill the requirements of the agreement does not fall under background IP. And thus, Theranos will not get a non-exclusive license to that IP. In the same way, foreground IP can be limited. We can limit foreground IP to being solely developed for and relating to the blood testing device. This way, any developments that are made after this joint development occurs by inventor A If it's an improvement to the device, it has to be solely for the blood testing device. If it's unrelated, if it has another purpose in the inventor A's development, then it will not fall under foreground IP. The next, we'd also like to provide a grant-back license for foreground IP to the inventor A. If any of the foreground IP does get assigned and owned by Theranos, we want to make sure that inventor A can still practice the technology, even though they may not have ownership or even exclusivity to it. So, the next scenario, 2, we're taking the side of Theranos. So once again, neither inventor A nor Theranos have patents for their technology. The technology is once again still currently maintained as confidential. However, the inventor is subject to an obligation to assign to a university. Theranos would like inventor A to develop the microvalves. The university requires that any IP developed relating to the microvalves is owned by the university. And the university would like Theranos to pay for further university research relating to the development of the microvalves and all costs associated with IP procurement and maintenance for the development of IP for the microvalves. Now, while this may seem quite heavy-handed, this scenario occurs quite often. Universities typically do not have large IP budgets, so they do rely on collaborators to fund some of the IP. In addition, universities do maintain their ownership at a high level because their inventors and their employees utilize their facilities in pursuit of that IP. So now we have the levers being pulled slightly differently here. Now we still have ownership, but we now have responsibility and opportunity. Here, it appears that both parties have a good opportunity for each other. The university would like to commercialize this technology. They would like to get some IP on the technology, so they're looking for somebody to pay for it. At the same time, Theranos is looking for this new technology to be able to utilize in their blood testing design. So there's an opportunity for both. But now there's a split between ownership and responsibility, being the responsibility on Theranos for paying for the IP and the ownership staying with the university. Now, Theranos is being asked to pay for any IP related to the microvalves. Now, what we can do here, one of the solutions, will be to utilize control and compensation. We may want to require that Theranos has a right to refuse certain developments relating to microvalves. Theranos wants control of where they spend their money. They don't want to pursue IP that they do not expect to commercialize. So if they can at least control what the university will be filing on, they can hopefully control costs that way. Second is compensation. Theranos may want to obtain an exclusive license to the IP that will be owned by the university that's related to the microvalve technology. This will allow them to prevent others from practicing the technology, from the university licensing to others to be able to practice the technology, so that the Theranos can hopefully recoup its investment, financial investment. Okay. Well, at this point, I'll open up I didn't see any questions. Does anyone have any questions?
Well, thank you, Jason. Yeah, as I indicated before, anybody who have any questions, please do submit them through the chat box. At the moment, I don't see anything in there.
Okay.
We'll just wait another second.
Absolutely.
And I'll take the opportunity to remind everybody that this presentation was recorded, is available on the for members in the member digital library. If you have any questions about how to access that, just give us a call at MichBio. In addition, if there are topics of any nature, legal or otherwise, that you'd like to see for future webinars, feel free to drop us a line at info@michbio.org, and we'll try to oblige. Last call for questions. Looks like you were too comprehensive and clear, Jason. So
I hope it came off that way. Sometimes this topic can be difficult to send through and digest.
well, if there are any follow-ups, then folks can get in touch with us, and we will connect them to you folks at Warner Norcross, and they can have those questions answered. But otherwise, that concludes today's presentation. We thank everybody very much for participating. Jason and Nicholas, thank you again for presenting. Greatly appreciated, and we'll see everybody next time.
All right. Thank you, Stephen. Thank you, everyone.
Thank you.